issue of same-sex marriage. And joining me now live to discuss that and the banking inquiry is the Liberal Senator James Paterson. Good morning.
Good morning, Sam.
Now, James, you've obviously played a very important role in terms of this legislation. First of all, you were proposing a rival bill. You withdrew this, but obviously you are now very engaged in the amendments. Take us through where we're at, because there are reports this morning that up to 5 ministers will be supporting some of these amendments, if not all, that you're proposing. But you've stepped back from some of the amendments in relation to essentially refusing service. So just tell us, where are you at this morning in terms of the amendments that we'll be going through?
That's right, Sam. So there's a last couple of second reading speeches to happen this morning, and I think we'll get to the committee stage where the amendments can be moved around about lunchtime, maybe a little bit before lunchtime today, and that could go for a couple of days. Myself and Senator David Fawcett are moving 5 amendments. Senator Brandis is moving 2 amendments. David Leyonhjelm is moving 2 amendments. The Greens have an amendment, and One Nation has an amendment. They all seek to do slightly different things, but there's some overlap. So, for example, David Fawcett and I, as well as Senator Brandis and Senator Leyonhjelm, all have an amendment which seeks to better protect civil celebrants. At the moment in the Smith bill, there are limited protections for civil celebrants that all of us would like to see a bit wider. So each of those will be debated, and I think some of them have a reasonable prospect of achieving.
And that would be a right for a civil celebrant to refuse to officiate over a same-sex marriage.
That's exactly right. So the Smith bill has protections for civil celebrants to refuse, but only in a limited set of circumstances. Each of our amendments in different ways broaden those circumstances, basically so that in David Fawcett and my amendment, any civil celebrant who doesn't want to officiate a same-sex marriage can decline to do so.
And why should they be able to do that if it's not religiously, not based in religion? They're not a priest.
Well, I think, and quite a few others, senators, think that being involved as the celebrant in a wedding is about the most intimate involvement you can have in a wedding. You're standing up there on the stage with them, and you are joining them legally in a union. Now, many marriage celebrants have a traditional view of marriage. Some of them have that based on religious values, but some of them just have it based on secular values. And I don't think that their secular values are any less worthy of protection than religious values. I'm personally not a person of faith, I'm agnostic, and I don't think my values are any less worthy of protection than someone who derives their values from a faith.
Okay. There's also some interesting reforms in there, I think, in relation to Sex Discrimination Act. Take us through what are the other elements in relation to that? Yeah,
so the Sex Discrimination Act changes are about protecting religious organisations that are involved in charitable work primarily. So we have a strange situation in Australia where a charity like St Vincent's de Paul Society, which most people would recognise as a Catholic organisation, a Catholic charity, is actually for legal purposes not recognised as a religious organisation. It's recognised as a welfare organisation, and that narrows and limits some of the freedoms, some of the protections that organisations like that have.
So they'd be able to refuse, for example, marriage counselling to same-sex couples?
What we're seeking to do is make sure that they can uphold their traditional view of marriage. Now, if they receive public funding to deliver services, they cannot discriminate in the provision of those services. However, we want them to be able to continue to hold and promote their traditional view of marriage if that's what they would like to do.
Why would they not want to provide counselling, though, to a couple in distress? Well, as a Christian organisation, I mean, why would they say, we don't want to counsel you?
Well, a good example of this, Sam, is an aged care home that's publicly funded cannot decline to have a same-sex couple stay in their publicly funded aged care home, but what they can do is continue to be an organisation that holds a traditional view in marriage and promotes that view of marriage. So it's not about declining to provide services.
Okay, but why would they want to refuse?
Well, I'm saying they can't.
They can't. Sure. So how would that play out then in an aged care home? If a gay couple, they can't say no to a gay couple coming to live in an aged care home, but they're allowed to uphold are they not going to celebrate their anniversary? I mean, how would that actually work?
It's just that these organisations are religious in nature and they have religious views, and no one should be able to take those views away from them.
But can you give me an example of what they would not have to do then?
Well, they would be able to say that, as an institution, their view is that marriage is between a man and a woman. That's their belief. They would be free to say that and promote that under this law.
So they'd be free to say, hey, by the way, we don't agree with you being married legally, but we can't say no to you coming here.
Well, they'll be able to say that the Catholic Church, for example, if it's a Catholic Church-run aged care home, has a view of marriage as it being, in a traditional sense, between a man and a woman.
Okay, what about this anti-detriment clause, this shield? How would that work?
So that's one of the biggest parts of our amendments, the most major amendment. Basically what it's trying to do is ensure that people who hold a traditional view of marriage can't be discriminated against for holding that view. So, for example, there are government agencies and arms of government which license professions, like doctors, for example. So a medical board which licenses doctors wouldn't be able to take away the licence of a doctor to practice their profession just based on their view of marriage. They could take it away for other reasons, but they could not take it away for their view of marriage.
Can you think of any other examples of how those shield laws would operate?
Yeah, elsewhere in the world, registration of other professionals like teachers and lawyers have been denied based on the educational institution they went to and the view of marriage that that institution promoted. In Canada, that happened at Trinity Western University. We don't want to see that happen in Australia. We don't want to see public servants fired from their jobs because they hold a traditional view in marriage.
Okay, and we saw obviously a very famous case in the United States where a woman, I think, refused to sign off on a marriage certificate in the United States. Would this law allow Australian public servants to refuse to work on gay marriage certificates? No. No,
it wouldn't. A public servant employed to do their job has to do their job, and they can't refuse to do their job. And if they refuse to do their job, then it's up to the public service to decide how to manage them, but including terminating them for not doing their job.
And is there anything specific in there in relation to safe schools?
Yes, there is. So within the anti-detriment provisions, or the freedoms protection provision that we're moving, is a right for parents to remove their children from class where the teaching is inconsistent with their views on marriage, just as parents today have the right to take their child out of a religious instruction class or religious education class. They should have that same right to take them out of a class that teaches them about the morality of sexuality and marriage, which is inconsistent with their views.
Okay. Just finally, on the Banking Commission of Inquiry, Barry O'Sullivan has told Sky News this morning that he's pressing pause, at least for 24 hours, in relation to putting forward the motion of his intention to introduce that legislation tomorrow, not putting forward that motion today. He's going to continue to talk to stakeholders and his colleagues, suggesting really that there are some other MPs who might be hopping on board. Do you think that the coalition is going to have to come to some sort of compromise on this, particularly if Barnaby Joyce is talking about perhaps joining the revolt?
Well, the government's view has been pretty clear on this issue, and I don't think the government's policy should change. I think a Royal Commission is a bad idea.
But the way forward might be the Dean Smith model, which is essentially you allow the Nationals and Barry O'Sullivan to put forward a private member's bill and you have that debate. Well,
we certainly can't stop any member from doing that. We didn't stop Dean Smith from doing it, and we shouldn't stop Barry O'Sullivan from doing it. Okay. It's something we jealously guard in the coalition, and while I would argue against it personally, I don't intend to dictate to my colleagues what they can and can't do with their private members' bills.
All right. What's your personal view on a commission of inquiry?
I think it's a bad idea. I think it's unnecessary. I think it'll be a distraction. I think it will harm the standing of Australian banks internationally, and I think it really is an unwise move.
All right. Thank you very much for your time today, James. Good to see you sticking with the small government approach that you learned at the IPA.
Thanks, Sam.
Thanks a lot.